by influencing our human autonomy, our decision-making process, or our behavior in a way where we do not remain the masters of ourselves. Here, the only thing that is needed is the likelihood of damages resulting from that manipulated decision, and that you would not have taken that decision otherwise. Well, it doesn't need a regulator because we have a ban, and a ban has civil law implications. And so if you have class action suits, and such as we have in the consumer rights context, that will also, I think, make it faster.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, the first rules of the EU AI Act started to apply last Sunday on February the 2nd. This refers to AI literacy or employee training, basically, but also refers to the prohibition of certain systems as per Article 5 of the new law, for example, employing manipulative techniques to distort behavior or exploiting age-related vulnerabilities. And now, many people are wondering whether some uses of AI in digital advertising or AdTech, as offered by large media groups or platforms, could fall under the new prohibition. In this context, the EU Commission released two separate guidelines on Tuesday and Thursday this past week on prohibited use cases and the scope of AI systems respectively. They are not binding and will have to wait for the courts to clarify certain things, but of course they help. The first one does say that AI-enabled targeted commercial advertising will be out of scope if it doesn't result in unfavorable treatment, for example, and we'll see what that means. Anyway, to make things more dramatic, Peter Hense, who was here on the show a few months ago, filed a first class action against X and TikTok under the DSA, the GDPR, and the now enforceable provisions of the AI Act, and this happened on Wednesday. So a really hot topic. I had the opportunity to talk to our guest today, Markus Wünschelbaum, a few days ago, prior to these developments, and he really nailed it on advancing the issues that eventually got clarified, confirmed, or simply made more confusing. Specifically, the prohibition guideline, the one from Tuesday, confirms the spillover effect of the GDPR, e-privacy, or even competition laws that Markus will refer to here. A reference is also made to studies on the harmful effects of social media on children, which we'll mention. As for Markus Wünschelbaum, he currently serves as Policy and Data Strategy Advisor to Hamburg's Data Protection Commissioner. In this role, he advises on key data protection and AI policies and strategic initiatives. Previously, he was responsible for imposing fines, fundamental GDPR issues, and freedom of information. He began his career focusing on the intersection of labor law and data protection, having published an acclaimed doctoral thesis on this topic and working at an international law firm. Let's go for it. Markus, thanks for joining me.
Thank you for inviting me.
Okay, so the AI Act is upon us, and there's going to be some overlaps with advertising. We said the same thing when the GDPR came with Article 22 and automated decision making. There were lots of articles about behavioral advertising and the potential and how it could be affected by Article 22. But now we've got the AI Act, and And so to warm up, can we start with Article 5 and some of the concepts that appear there and their prohibited systems? What do you think about that?
I think that you mentioning Article 22 is really interesting because that's one of the few instances where the GDPR actually says something is forbidden in that sense. And so that's why I was also reminded of Article 22, and I tried to compare the two. And there are similarities, but definitely huge differences in that sense that I think that Article 5 is way more powerful. And to just get a broad overview of what the Article 5 actually does, it prohibits or bans certain AI practices. And one thing that's interesting, because everybody is talking about, is my system high risk? Isn't it high risk? Everybody doesn't want to be high risk. How do I get out of high risk? This doesn't concern high risk. It just concerns all AI systems. It doesn't matter if you're a deployer. It doesn't matter if you're a provider. All these kind of things that people tend to argue about preemptively do not matter. This concerns all AI systems. And basically, there are three kinds of AI systems that are being addressed. The first kind are AI systems that influence behavior directly by influencing our human autonomy, our decision-making process, or behavior in a way where we do not remain the masters of ourselves. And that is one kind of ban that we today might also talk about the most. The other kind is indirect influence on autonomy and manipulation that causes like detrimental effects. That's social scoring or predictive policing, for example, or emotion analysis in the workplace, everything that has a chilling effect in that sense, where you're not directly influenced, but the monitoring occurs in a way where you might not act in the way that you would act otherwise, but you consciously do so. So that's different than being manipulated. And the third kind is like classical government surveillance. Is AI used to gather massive information to identify people in real time, to create facial recognition databases through scraping? That's the third kind of thing. And so those are the three things. And I think what we can focus on if we talk about ad tech, for example, or social media and the like, we can talk about direct influences on people's behavior that are not social scoring or predictive policing, obviously.
So there's this idea, right? These AI systems will be prohibited. And we've got deploying subliminal, manipulative, or deceptive techniques to distort behavior and impair informed decision making, causing significant harm. What's manipulative?
So yeah, let's talk about what manipulative is, and then maybe let's talk about also what an AI system actually is for a little short while,
Please.
because I think many people in ad tech will first be like, well, manipulation. This doesn't concern me. We don't use AI systems with legacy systems.
Yeah.
But yeah, what is manipulation? Basically, manipulation means that any kind of technique that subliminally influences what you do. So, for example, a subtle color change or a layout that would exploit your cognitive biases. Like that could be seen as manipulative under Article 5A because you don't see what is happening. You do not perceive it. It is subliminal. It does influence your subconscious, but you do not know what you're doing. In contrast to social scoring, you definitely know what is happening. You're afraid that you will not get a service if you get a parking ticket for like two more times. Like you know what's happening, but a subtle color change, a layout change, or something popping up all of a sudden, that's not something that you can influence. And that's the kind of difference that you can make there. And so if we talk about ad tech, it's kind of interesting to think because, of course, a lot of these systems in real time can change the way that a product is being presented based on the behavior that you presented before. And to a certain extent, this is the selling point of personalized advertising. We offer you something that you want.
Yeah.
And the question is, do I want it or are you making me want it? And I think the Article 5 goes into this gray area in a way that is really different from Article 22. Because what Article 22 did, and that's why it's not really as powerful as Article 5, I believe, is that it said that such automated decision making is not permitted, with certain exceptions, if we have a legal consequence. Now, convincing you of buying something is not yet there. That's not a contract that's being made, or that's not a decision about your credit score, okay, about the credit score that then influences if you get a credit or no. But ad tech is a little bit more far removed, which is why we have not seen many cases concerning Article 22 GDPR. Here, the only thing that is needed is the likelihood of damages resulting from that manipulated decision, and that you would not have taken that decision otherwise. That is way, way, way broader than like a legal kind of thing that comes from this. This could be any kind of decision that you make. And of course, decisions are being manifested often by purchasing something, but that doesn't have to be the case. And it's interesting because AdTech makes so many, has so much data concerning conversions. Conversions. This is the most important thing. Like, do we have an event that's happening that we log? Well, this could be a great documentation of decisions happening
Yeah.
by the consumer, because then you can actually say, we did this. Okay, let's talk about if this was subliminal. Give me all the data that you have on your conversions that you collect dutifully, because you have to show that your system actually has some return on investment. And then I can tell you, well, interesting, we had certain events happening because of the technique that you used. Explain how this is not manipulative.
So we've got both things combining. If you look at a TikTok feed, which is already looking at your behavior and how you scroll to customize the content, you combine that with your conversions, and there's a very strong element of manipulation if you look at it from a certain point of view, because you're not in control of the things that you see. And then, but yeah, we're getting closer to what we always wanted from advertising, even on TV. As we had more and more channels, it could be argued that it's simply being personalized. It's taking less of your time because now it adapts to your preferences and interests. So where is the line? And so, yeah, that is very interesting. So we have a little safety net, as you call it, which is a recital 29. So what is this about, please, in recital 29?
So result 29 is interesting because, for one thing, when you read the Article 5, the language is so broad. You basically have to think, am I making things up? Am I creating a use case that the legislator didn't think of? That's what's happening most of the time if you read these, like the AI Act, basically all the time. And when I read the AI Act, I was reminded of CPDP last year. I participated there, and
Yeah.
people were discussing personalized advertising, and people were discussing it and saying, well, the GDPR should have banned it. And other people then said, well, but it didn't. So we cannot just say it's illegal because we don't have the law for it. And now I was reading the Article 5, I was reminded, and I thought, wait a minute, is this the ban? And then I looked at the recital, and there it says, in addition, common and legitimate commercial practices, for example, in the field of advertising, that comply with the applicable law should not in themselves be regarded as constituting harmful, manipulative AI-enabled practices. So basically, on the one hand, I was happy. I was right. Someone thought of advertising when reading this. This is a classic case of advertising. At the same time, I was a bit relieved because I thought this would be a major issue if then we would ban advertising, because this does not pertain to personalized advertising. Regular advertising is also playing with our behavior and trying to influence us. And so it was interesting to see that they would cut it out in that way. But at the same time, you really have to pay attention to the wording here. Advertising that complies with the applicable laws. So basically, it takes all the fights that we're having right now in GDPR and e-privacy law, and it transforms it into an AI Act question. Because basically, what you now have to do is show that maybe you don't have a manipulative ad tech, fine. But if you do, what you then have to show is compliance. You have to be compliant in order to get out of this. And the trigger is stronger because on the one hand, you would have to be compliant because you don't want any action by a DPA, because you don't want any action filed against you for damages. Okay, but there's things that need to happen in order to have that risk be realized. Here you have a ban. So you're not allowed to practice. That has influences on competition law. That has it's consumer protection law. It's civil law. It's damages law. It's so many things. We don't often have this in digital European law, like an outright ban of something. So the repercussions here are interesting. And in the end, I feel that Recital 29 gives you sort of a pre-compliance to the AI Act because you basically have to look at what you have. Do you have an AI system? That's something that you would have to ask yourselves about high-risk AI systems as well. How does this AI system work? Is it compliant with other laws? That's basically what you would have to do if you have a conformity assessment. So basically, what it does is give you a new kind of a new kind of deal to look at everything that you have and check if it's compliant, because the risk there is real. And I think that is really interesting because it's kind of hidden. It's not apparent, I feel. And people do not talk about this ban in that way that it has practical implications.
It's very good. It's sort of a spillover effect. So you fail somewhere else, and all of a sudden you're running afoul of the AI Act. And so let's retake the notion of a system. We did this 2 years ago, and it's time. What is a system as opposed to a model and other concepts in the AI Act, please?
Let's do this. So basically, the AI Act regulates two different things. It handles systems and it handles models. And the model, this example is often cited, but would be GPT 4.0, o1, o1 preview, all the ones that pop up all the time. And the system is the one thing that didn't change, ChatGPT. So if people talk about something new, it will be a model. And the system is basically the interface of the model, the way that you can chat with the model, and you have filters, you have enrichment, you have retrieval augmented generation, you have all these kind of additional things that then make it into a system. And the AI Act regulates, mainly the AI Act regulates systems. It only started regulating models when we suddenly realized that there is ChatGPT and the legislator was kind of panicking. But in general, if you talk about AI Act regulation, it's about systems. So ChatGPT, AdTech is a system. It can work with a model, and then that model would be regulated if it has a certain size, it fulfills a systemic risk and so forth. But for normal kind of users in like SMEs and the like, it's about systems.
Yep.
And so every person would then ask, okay, great, thank you for that, for telling me that I don't have to care about models. What is a system? And it's interesting because there is a definition in the Act that concerns systems, but it's infamously broad. And nobody really knows what an AI system is in the sense of what isn't an AI system, what is only an IT system. And if you look at right now at publications that you have by authorities that will then decide on this, you can see that it will be broad. So, for example, in December, the EDPS, the European Data Protection Supervisor, who at the moment is the only market surveillance authority in Europe, because they have been declared the market surveillance authority for European institutions in the AI Act, has issued their thoughts on the Act. And they said, critically, but they said, in our view, all IT systems may be considered autonomous as they do automate calculations and processes. And they said this is a problem. This term, we cannot really say what isn't an AI system in that sense because the term is too broad. And it's interesting because the Commission will now issue guidelines and tell us what an AI system is and what isn't. And Luca Bertuzzi, who used to work with Urlex and now works for MLex, he's really good, really great, insightful posts on LinkedIn, really current. And he has said that the banks, for example, they have been lobbying to exclude logistic regression. So basically their scoring system from the AI Act because they thought, well, it's a legacy system. It's a rule-based kind of system. This is not a language model. We cannot say that this is no neural net. And the commissioner basically said, no, no, no. We think that this also is considered to be an AI system. So to everybody who thinks that AdTech is fine because it's legacy and it uses algorithms, but not these kind of algorithms, I would prepare that a legal memo and red flag the risk in this, because it seems like the AI system is interpreted as a broad system. And I've read something that was really good by Peter Hense and Thea Mustac. They have a great book, AI Compact, it's called. And they basically said, whenever you have to think, if you have an AI system in front of you, yes or no, it's probably an AI system. That's the rule of thumb that they did. And I think it makes sense because since the terminology is so broad, it doesn't make sense to get out at that stage. There are other stages in the act where you can try to get out, but I think it would be too much of an effort to try to get out, and the return on on compliance is not high.
That's very good. For many years, all these agencies, media agencies, advertising agencies, have been showing off their AI capabilities, and other downgrading them so they do not get categorized as a system. Same as you're saying with the bankings and scoring system. I was interviewing the director of one of a pretty large agency recently, and he was talking about how they use Gen AI to produce creatives and how to adapt creatives, and everyone is doing this. If you listen to the rationale for the recent merger in IPG, Omnicom, or what WPP is saying, they're all boasting of their ability to create, again, ads, banner ads, display ads on the fly, and to do it, again, through Gen AI. So all of these would now need to do something very basic, even if they are not forbidden, again, because we need to prove they're manipulative and everything we've said. But what do we do with, and that's probably our last question, but what do we do with transparency? What do we do with their basic obligations not being forbidden, but simply for the very reason that they are now using a system and they need to comply with basic transparency? For example, when it comes to a potential bias, even with regards to copyright, which is also, there's also an overlap with that. So how do you see these ads being affected?
I think if you use an AI system to generate images or generate text, it's not in advertising, it's not that different from many, many, many other SMEs and companies using chatbots to generate text. And they will be dependent on the big providers of AI systems to give them the information that they can then have. What will be happening, I assume, is that all the big players will come up with tons of documentation that will be more or less helpful. And then the SMEs will have to just take it or leave it. And that will be the only way for them to demonstrate compliance. And they, I would say, have time to be compliant because in 2026, the AI risk compliance duties will only be there. And then you will have transparency issues when you use GPI systems. That's Article 50 Act and so forth. So I would say these people who use like everybody does, kind of, they have time. Who doesn't have time is AdTech. So because of Article 5 and because of the subliminal techniques and the kind of manipulation that is like the elephant in the room, that always has been the elephant in the room with ads, they have to address it now. And the reason is that it's not really about, because one might ask, well, why do we have to be compliant if there's no regulator yet? Well, it doesn't need a regulator because we have a ban, and a ban has civil law implications. That's the big thing. Or, for example, in data protection law, this is an illegitimate purpose. Any data processing that would aim towards a system that does something that would fall under that ban could not produce a legal ground just because Article 5 says that all purposes have to be legitimate. We cannot process data for something that is forbidden. And that is also a major compliance issue because basically your whole use case is now under scrutiny. I'm not saying all AdTech use cases are done now. What I'm saying is there needs to be scrutiny and there needs to be a good compliance documentation of why you think that this system is not a subliminal manipulation or falls under the recital and therefore is something that is compliant. Now, the same questions that we have in data protection will then have to be answered as well, but there's a new trigger. And I think that's fascinating, honestly, from a legal perspective and from a regulator's perspective. It's interesting, to say the least, because we now will have some enforcement coming from civil law. Because one should not forget that we have Article 110 AI Act, which opens up civil law cases. I mean, for class action suits, that's what it is. And class action suits in data protection law are not that common. And so if you have class action suits, and such as we have in the consumer rights context, that will also, I think, make it faster when it comes to compliance. And I can imagine that some people are already preparing something for February, because why not? It's easy. Just to claim it in the beginning, to sue and to just take the law with its broad wording and say, well, AdTech falls under it, social media falls maybe under it. Because with social media, it's even more apparent, because there, if you talk about TikTok and the addictive kind of effects that it has, we have the second kind of ban in B of Article 5, which says that if you use these kind of techniques to use the vulnerabilities of certain groups, such as young kids or adolescents, then that causes a harm, you're also under that ban. So if you think about TikTok and them kind of, I remember, okay, not TikTok, but let's go back a time. Do you remember the Tide Pod challenge?
No.
So when Tide, the washing detergent, came out with the Tide Pod, these kind of translucent things that you can put in the washing machine, kids began on YouTube to chew on them.
No.
And it became like a thing. It was a challenge to try to chew on them, and people got into the hospital. And so the question that would arise then is, did YouTube kind of push the algorithm because kids would watch that? Or did they not push it, or did they even take it off? Because I'm pretty sure they didn't. And so the question would then in social media be, now, do they have, apart from the DSA, which has transparency requirements, and there may be a ban if the agency that is in charge of enforcing the DSA would then enact it. But if you have these kind of things that influence children or adolescents, then you have a ban immediately and a class action suit immediately. And that changes a lot. And it's quite apparent in these kind of challenges that often come up, and where the algorithm is kind of, works in a way where children want to continue to watch it, that in these cases, there is a harm because they actually harm themselves because so many are doing it. It's quite apparent, and it's interesting to see how this will play out.
Oh, that is such a good point. We're going to end up with a very American landscape, so to speak, with the class actions.
We'll see. It's an interesting time to be a regulator.
It is, absolutely. Markus, thanks again. Thank you very much.
You're welcome. Thank you so much for having me.
Okay, that's all for today. Follow us on Blue Sky, and in the Masters of Privacy Altogether profile, you will find the starter pack, which includes the feeds of all of our past guests. There is also a Masters of Privacy LinkedIn channel, which I invite you to follow, where you will find links to our transcripts, cheat sheets, and other surprises every now and then. Our main website is mastersofprivacy.com. Thank you for listening.